Could I just have one moment, my lord? I have a note to add.
Yes, of course.
I've got it in front of me now. My lord, this is an important and interesting point, because your lordship commented this morning on the recent report with regard to the new COVID infections on the island.
Only from Sky News. I have no other information.
I thought your lordship was referencing the Royal Gazette before.
There was the Royal Gazette, obviously the Royal Gazette report of yesterday's press statement.
Yes, and that is, so I took the opportunity to glance at that, my lord, and this is what is interesting. Obviously, this is from the government report on this.
Yes.
That relates to passenger arrivals. And if one follows that logically, my lord, 4 out of 5 of those positive tests were likely vaccinated people. 4 out of 5. 2 were tourists.
I'm not sure how you get that.
I'm sorry?
Sure how you get that. I'm not sure how you get that, because if you look at the table, which is in Dr. Weldon's affidavit, right, you see that the vast majority of the people who test positive are unvaccinated, something to the tune of like 94%. And very few who are vaccinated are in fact test positive. And it's all set out of the entire numbers.
Yeah, no, I saw that. I was referring to what the recent government reports are that we just got hot off the press. With regard to just in looking at it, I've taken the chance to look at this. At least the ones that just came out, so it wouldn't have been in her report. 2 were tourists, so they weren't in quarantine for 14 days, so they would have been vaccinated. 2 were positive on day 4, so they wouldn't have been in quarantine because there's no mandatory quarantine, because there's no day 4 mandatory quarantine tests, so they were vaccinated. The 5th was a positive on day 3. That would have been an unvaccinated person.
Yes.
And then 2 had to be vaccinated, or they would have been in the mandatory quarantine. So on the logic of the government's own report, it would appear that 4 out of 5 of the recent positives were in fact vaccinated, but it's beyond a doubt that 2 were.
That does not sound right to me, Mr. Pettingill. Obviously, I don't have the figures in front of me.
No.
It does not make sense that out of 5, 4 would be vaccinated.
One would like to think that would be the case, but on the basis
of entirely contrary to the affidavit evidence which is set out in Dr. Weldon's affidavit.
My lord, that's why, with respect, and no one's had a chance to respond to it. By the way, I mean, so a reply is coming. I want to raise this now because I think this is relevant information that, you know, if we have to go back and look at it, we can always endeavor to address it if it's just come in, which it appears to have done.
Well, perhaps Mr. Duncan can get proper instructions in relation to the numbers which are said to be positive yesterday.
Yeah.
What percentage, how many were vaccinated and how many were unvaccinated? And we can get it from the appropriate authority, so we're not just speculating.
Quite, my lord, and I don't want to do that other than the basis I was taking from the report and looking at it. I found it suddenly startling that appeared to be.
That would be startling. That would be startling. Out of 5 people, 4 were vaccinated who was tested positive.
I think, my lord, that as I say, on the read of it, it would appear to be 2, but I would be obliged that we really should, in light of this hearing, and that this is new evidence that has come to light as of today, it would be useful to have that.
My lord, my only question with respect to that is what aspect of the test that I'm going to draw your attention to is that relevant to?
I have no idea, but I mean, it just seems to me that the statement from the newspaper that Mr. Pettingill's analysis based upon the newspaper that 4 out of the 5 people who tested positive in the last press report must have been vaccinated doesn't sound right to me, and it was for that reason I said perhaps one should get the right figures. I'm not sure it has any relevance to anything.
Thank you, my lord.
Thank you, my lord. I'm obliged having in the right figures, because that's all I was really hoping to achieve by that. The knowledge is power. My lord, I'm going to wrap up at this stage, if I may, where I indicated. So I'm at paragraph 48.
Yes.
Thank you. So, my lord, this is on my, if you will, the filter down position with regard to consideration of less intrusive means and what could have, taking the test of reasonably required, be properly made use of. So, my lord, at paragraph 47 of the Mellett case, it reiterates that it was a highly relevant factor that compliance with guidance by the majority of the affected group had been very good. And I would say that's the case. That would be the case here as well, from what we've seen.
Well, that's not the evidence, though. I mean, I mean, at the moment, we've got to go by what the evidence is. The evidence from the Minister of Health, Ms. Wilson, is to the contrary. I mean, that's the whole burden of her affidavit.
Well, but again, I think we're on the same page, my lord, that it was highly speculative in saying that there was this one group that may have done.
It's not speculative. If you look at her affidavit, right? I mean, it's important to actually look at what's been filed here. Ms. Wilson says it's at tab. Let's get to tab 15, I believe it is. She says that paragraph 21, she refers to the affidavit of Dr. Joanna Peden.
Yeah.
And she says the paragraph 22, while I note that the applicants say in their evidence that they would quarantine at home, this is simply not realistic for all those arriving in Bermuda based on what the government has experienced to date. There are numerous examples that have occurred in Bermuda that justify the need for quarantine to occur in a hotel. I have set out a number of examples below, and the rest of the affidavit then sets out actual examples of what happened in Bermuda, including the one which she says potentially resulted in the deaths of 21 people.
May have resulted in the deaths. Yes. Yeah.
Yes. So yeah. I mean, it's not speculation. This is the Minister of Health giving evidence.
Yes, my lord, accepting of that, I think that one would then take the position from those examples. If those are the examples she draws on, there are a multitude of other people, because of what the case is saying, that the overall compliance has been very good, if not, excellent with regard to it. So when I begin to speak about less intrusive means, it's including those factors that would have been of concern before and what can be done that is reasonably required now, because the mandatory quarantine only came into effect a week or so ago. And what we're saying is there needs to be consideration, bearing in mind what the minister says there, and as I had said earlier, about clearly it's the fact that the majority of right-thinking, law-abiding citizens will be compliant. That's number one. And number two, out of the concern for those that would not be, how can one reasonably address that? And what we're saying is, and I'm going to go through it now, is that there are other less intrusive means that are reasonable that would address that position without going as far as an enforced mandatory 14-day quarantine. And that is the balance of interest. And the question with respect, in my view, for the court is, and should be, is there in light of all of that evidence, is there a less intrusive means that would be appropriate and would address the mischief, if you will, in the circumstances? Well, Lord, at 49, the respondent's own expert report concedes, and this is the report, my lord, of Dr. Peden, which is at tab 19, I believe, at paragraphs 12 and 15, that people that are placed in a position of this type of enforced quarantine will suffer from feelings of isolation, loneliness, and loss of community, in addition to financial worries and difficulties. We would say that these are all factors that the court should address and should consider in light of the constitutional rights, something that's not addressed there, of the applicants, as to whether there is a way to achieve the same ends without subjecting those individuals to those health risks. And bearing in mind the balance that your lordship says, you're not dealing with just, I heard your lordship on this initially, you're not just dealing with the concern about the individual, but it's the whole community. But it is striking a balance nonetheless, with regard to how both of those things can be accomplished. And what we say by this is that they can be accomplished by less intrusive means than the government has implemented. My lord, at 50, the respondent's discretion is highly fact and context specific, and the decision to implement the mandatory 14-day quarantine had to take account, or should have taken account of all relevant circumstances, including the provisions prevailing at the time the decision was taken, and the reasons given why less restrictive measures were rejected. My lord, in this regard, the applicants, for the purposes of this assessment, the court can interpret the decision and the date of the regulations became effective, namely, which was the 18th of July, not much earlier had been anticipated. And on that basis, Bermuda's epidemiological status as at that date would be highly relevant. The respondents have notably failed to provide any evidence of the same, and have therefore failed to discharge in our submission their burden of proof in that regard. I touched on this before, my lord. If it was to your lordship's point in asking the question of counsel with regard to the pandemic, which I conceded obviously addresses the category of a health crisis as far as the Constitution goes, it must have been significantly relevant at the time that was considered, but there was still this delay in the implementation, which we would say is a consideration when it comes to the balance of interest as to what is reasonably required to ensure that there is not a further spread by those individuals that are unvaccinated. And my lord, if I could just, without reference to the submission, but in closing this element of the submission, just for consideration, and I touched on this earlier, there is no valid reason, in our view, in moving slightly back. And I only say slightly because the quarantine is still quarantine. Let's start on that basis. We're all ad idem on there should be a quarantine, accepted on the science that quarantine is an effective tool and an effective measure. It's the basis of the whole case as to why that quarantine must essentially take place in a hotel when, with the right reasonable provisions in place, it can take place at home. And one has to consider that, my lord, in the context of what Bermuda has accomplished. We have safe key. We have the ability to have people with monitors, which, my lord, reasonably they can pay for. So it's more than reasonable to say you can have the choice if you can go in a hotel and you can pay for that, or you can pay for a monitor and you have to stay at home. It's more than reasonable to say that if you do not, the penalties because of the health risk that you will pose are going to be extremely stringent. And nobody, certainly applicants, could complain about that, whether that's $20,000, $25,000, or whatever it is. Something that is really reflective of the seriousness of any quarantine breach, which currently, as we've had no prosecutions, doesn't seem to be, the case or have been addressed. This is a matter of simple regulatory position that can be done overnight and has been done. The ability to apply the money instead of going to a hotel to more regular checks, whether it's by regiment or health workers. You're covering overtime, you're covering additional people. We need to employ people. So this is a good example of where the government can actually do something very positive community-wise by applying the private funds to the ability to check people at home. Your Lordship heard me earlier in giving evidence, but I believe it was accepted, that checks are going on anyway, and they're appropriate checks, whether they're by phone call or whether they're by actual checks at a residence. That all of those things can be done, have been being done, and could be done even more so. The ability to put a notice on the door and cordon it off, as I'd indicated, and finding people that endeavored to breach that. I mean, I would say, even, my Lord, the risk of having people at a hotel. It could be that it could be a husband or a wife or a wayward girlfriend, a boyfriend, that decides they've got to see their loved one, and is going to try and sneak into the hotel. All these types of things, and there should be a fine position and legislative position with regard to that type of activity for people that are not in quarantine. Would be a reasonable approach, but no reason not to do that at one's own home when you bring in the balance of interest on the health benefits to people being in their own home environment is significant, and is actually indicated by the expert reports and by the report of Dr. Peden. So there are, in fact, all of these reasonable measures that could achieve the same ends, where we are all ad idem, my Lord, both vaccinated and unvaccinated. And that those, and it's not the evidence of it, those, my Lord, in relation to the Premier's affidavit, the things that I have mentioned to counter that can all be accomplished, and are common sense approaches to how this can be dealt with, especially when it comes to the application of the funds. If you're going to pay to stay in a private hotel, what's the difference with paying to support the measures that the government has to take because you make the choice not to be vaccinated? And one isn't saying that because you make that choice in the time of a pandemic, that there isn't some repercussion as a result of that. If the evidence speaks to that it may be, or is more likely, that by being vaccinated, it is more protective of the position, then the applicants and people generally that choose not to have the vaccine have to be accepting of the position that there is something more onerous that may apply to them. And one would be at great pains to argue against the reasonable measures that I have laid out. And I would urge that the constitutional consideration for this court has to be, or must be, with respect, my Lord, how what the government has imposed by way of mandatory paid for quarantine by unvaccinated people in all of the circumstances unreasonable for all of the reasons set out? And are there other approaches that can achieve the same ends without the need for people to be isolated in a hotel? And we say, my Lord, that the answer to that has to be a resounding affirmative response, and that the position with regard to a reasonable requirement to protect the public interest can be accomplished by those measures. My Lord, those are my submissions at that time, subject to any questions your Lordship may have at this point. Otherwise, I reserve the right of reply on whatever may be raised or on the law, on the legal position.
Yes. Well, thank you, Mr. Pettingill.
My Lord.
Mr. Duncan?
Yes, good afternoon, Lord. Do you have a copy of the response to the note re respondent's delay in filing evidence that was sent this morning. I'd like to start with that as what I would call a preliminary point. My Lord, it is a response to the note produced by my learned friend, and you may have his note.
I do.
Paragraph 7 of that note refers to an announcement that was made by the Premier on the 27th of April 2021.
Yes.
Now, my Lord, we are in the odd position where in the originating summons that has been filed by the applicants, there is no reference to the regulations that they seek to challenge. Effectively, as I say in paragraph 2 of that note, the applicants seek to have this court make a declaration in relation to a statement. That statement is dated the 7th of May, and it was made by the Minister of National Security. And I just raise it for concern for the court, namely whether a statement is justiciable by way of a declaration, when in fact the regulations that they seek to challenge have not been mentioned in their originating summons, not mentioned in their pleadings, not mentioned in the evidence, not mentioned in their written submissions.
I think they were mentioned in the submissions. In relation to the injunction, there was some reference to either proposed regulations or I have a feeling that there was.
Yeah,
Regulations.
we now have the regulation we have now, tab 3 of our authorities bundle was enacted after the injunction hearing.
Yes.
On Friday.
And so there now is a challenge to a statement. And I think the court has to consider whether it's, or put it another way, how would you make a declaration with respect to the statement of the 7th of May? Because that's what's pleaded in their originating summons. And I just raise it because I think there is a problem there. Whether or not, in fact, that statement of itself is justiciable.
Yes. Well, look forward to hearing Mr. Pettingill on that.
So, my Lord, turning to the application in general, Lord, if you could have our written submissions. We start out with some factual background.
Yes.
Page 2, paragraph 2. And my Lord, I'm not going to read the extract from Dolan because you've already not only seen that in the interlocutory hearing, but I think
I can tell you, I've read the Dolan case both in the court below by Justice Lewis and the Court of Appeal judgment.
Thank you, my Lord. And one of the things to note, and I'll come to this later, was I think a reference that you made to a paragraph in the Dolan judgment on appeal may have referred to whether or not it was appropriate to consider legislation that had been passed, when it would be more appropriate for that to be debated in the House and there could be some challenge to that. The reality is the case also refers to regulations because that's what the case was about. And so I just want to draw your attention to the fact that at tab 9 of our binder, the first instance case of Dolan is referred to.
Yes.
And sorry, it's tab 8, but it doesn't really matter because it's the same.
Which paragraph?
If you look at paragraph 8 at first instance and paragraph 15 on appeal, you'll see that they're dealing with regulations.
So these are regulations made by the Secretary of State without reference to Parliament.
That's correct.
Yes.
So, my lord, we are aware that by virtue of paragraph 3 of our submissions, this pandemic descended on Bermuda in March of last year. And the impact of the pandemic led to the governor officially declaring a state of emergency. I won't take you to that reference, but you can see in paragraph 3, there is a reference to the actual declaration of state of emergency at tab 20. And you can see, my lord, that shortly thereafter, the minister, in consultation with the chief medical officer, the CMO, declared that there was a public health emergency in Bermuda pursuant to sections 107A and B of the Public Health Act 1949. And my lord, the background to this case, and indeed the regulations that have been put in place, or the order that's been put in place, has been the variants. And at the interlocutory hearing, I took the court to the case of Spencer versus the Attorney General of Canada. And I referred to that in paragraph 5 of the written submissions. I think it's taken as a given on both sides that there are variants, and those variants are in Bermuda. And indeed, Dr. Weldon refers to the variants, and I'll be taking you to her evidence on the variants later. But, my lord, paragraphs 15 through 17 were read out at the interlocutory hearing. And so I don't propose to read it out again unless, my lord, there's something in those paragraphs you'd like me to address.
No, that's fine.
Lord, turning to paragraph 7, vaccinations became available in Bermuda at the start of this year. And again, later on, I'll take you to the evidence when I deal with the De Freitas test, that the vaccines have been found to be effective. Obviously, the level of uptake of those vaccinated is a moving target. But the critical concern for the government is those who are unvaccinated. And so these measures are designed to protect the community as a whole, including those who exercise their right not to be vaccinated.
Mr. Griffiths this morning was saying that these figures may not be accurate today, which is probably true, because he was saying that as far as total vaccination was concerned, it was around 63% now, as opposed to 60%.
That may be correct, my lord. the vaccination uptake is a moving target. If it's an up-to-date figure, I'm quite sure that the Minister of Health, who is participating in this hearing, can provide those figures. If that is an issue, that is not a problem. But as at the writing of the written submission, the relevant numbers were that, and this is in paragraph 8 of the submission, 31 deaths, 2,514 confirmed cases. There were at that time 19 active cases, and then you can see which variants they break down into, and some are undetermined.
Yes.
Now, my Lord, I think it's important that we look at the actual legislation that's challenged. And we see the challenge that has been made by the applicants in their expedited originating summons. Lord, if I can ask you to look at paragraph 23 of tab 3 of the hearing bundle.
Yes, I have it.
So what is said is that the prayer for relief is for a declaration that the mandatory quarantine is and or will violate inter alia the constitutionally enshrined fundamental rights to freedom of movement pursuant to section 11 of the Constitution. That's what we have. And here is where the problem lies for the applicants, because that relief that is sought, Lord, do you have it? The hearing bundle, it's tab 3, that should be an orange colored tab.
I have it.
Paragraph 23.
Yes.
Paragraph 23B in particular.
Yes, the difficulty arises with the definition of mandatory quarantine. Because
Yeah,
the mandatory quarantine defined in paragraph 18 is a statement.
Yes. Yes. Paragraph 18 is the statement. So, my Lord, essentially what's happened here is the case was presented for the interlocutory hearing, and the challenge was based on what was available at that time. We now have the order, which I'm going to go through in some detail. And the question is, and this analysis is in part prompted by an exchange that you had with Mr. Pettingill, in which you sought to extract from him those portions of the actual policy he objected to and those he didn't. And the reality is the order contains a number of provisions that deal with a number of the concerns he has. And so one has to be very careful about exactly what it is he is seeking to challenge by way of paragraph 23B in his expedited originating summons.
I mean, it's quite clear the originating summons was filed in anticipation of amendments being made. And that's why paragraph 16 refers to the proposed amendments.
Yes. Yes, my Lord. So let us have a look in particular at the...
So the regulations are at tab 3 in the authorities.
Tab 3. So, my Lord, let's go through them in some detail.
Yes.
So if I can ask you to start at part 4. This is quarantine requirements for travelers.
Yeah.
So you can see quarantine for travelers with COVID-19 vaccination and pre-arrival COVID-19 PR test. That sets out the requirements. Importantly, at paragraph 12A, there is mandatory quarantine for travelers arriving from specified countries. So there is a distinction there depending on which countries you have come from. Paragraph 13 on page 12.
So just pausing there. So would that apply to a person who's been vaccinated? The requirement in relation to coming from a specified country, or not? No.
I can get instruction on that, but I assume that if you are coming from a country, not meaning to single out any particular country, but let's say you're coming from India, which has a very high risk, there may be a concern that you could be carrying a variant. So, I mean, I will clarify that, but I would have thought that some of the what they call red zone countries, would be of concern. Then, my lord, if I ask you to turn to section 13 on page 12, mandatory quarantine for unvaccinated traveler. This is the, I think, nub of the complaint that is anticipated in the challenge to the proposed regulations. Well, if I can ask you to just read that rather than me reading it out.
Yes, I've read it.
My lord, and you'll see paragraph 13.3, where a person to whom this paragraph applies receives a negative COVID-19 PCR test result on or after a period of 14 days, he shall be released from quarantine and be provided with a written notification of his test results. And then, my lord, paragraph 13A, exemption from mandatory quarantine and quarantine requirements for exempted travelers. Subject to the other provisions under this paragraph, paragraphs 12A, 13 and 14 shall not apply to a person who, upon being landed in Bermuda, who is A, medically vulnerable, as certified by a licensed physician, psychologist, or local health insurer. B, a caregiver that is accompanying a person under subparagraph A. C, a minor child below the age of 18 years, one unaccompanied, or two with a parent or guardian who is vaccinated. 13A2, a person referred to in subparagraph 1 shall provide to a health officer upon arrival in Bermuda such documentary proof of the exemption from mandatory quarantine referred to in paragraph 5.6, which he received from the quarantine authority.
So and then the rationale behind 13AC, the minor child below the age of 18, traveling.
That has to be read with unaccompanied. I mean, if there's a minor child who is unaccompanied, the thought is that they may not have had the opportunity to get the vaccine. And so, they wouldn't then be able to satisfy the requirement. And if that child is with a parent or a guardian who is vaccinated, then they would be exempt. So the child would be vaccinated, but the parent or the guardian would be vaccinated. So that child would still be exempt.
Yes.
Paragraph 14B. And then importantly, that's with respect to costs, but there is an exemption there depending on the date of your travel or the date you made travel arrangements. So if I can ask you to turn to part 6 now. Where is that? Yeah, right, yes. Lord, I forgot to mention section 14b(2), which is part of our case. So these regulations, this order is due to expire on the 30th of September. And that's
where do I see that?
Section 14b(2). So on page 15.
Ah, yes. Yes. It expires on the 30th of September.
Well, yes, that's important for more than one reason. It's important with respect to the nature of the encroachment on the constitutional right, the time of it. It's important also in respect of the evidence that you have from the applicants with respect to their lack of evidence of travel that I'll come to later on. How does an order that has an expiry date within...
So realistically, one is looking at these restrictions existing for a period of 3 months.
That's correct. And that's a relevant factor. And my Lord, there are moving scales that the government is trying to balance throughout this exercise. So this provision is in place for 3 months. As the uptake of the vaccination hopefully increases, as we get closer to herd immunity, as the government is in a better position to relax the measures. And this is why so many of these polycentric decisions that the government have to take, which are finely balanced, and I don't mean finely balanced in a way where we can't have access to them. They are just fine balanced judgments that it is difficult to attack based on individual analytical complaints that aren't addressing all of the polycentric issues the government has to consider.
Yes.
So, my Lord, if we can turn to part 6. Now, this addresses the example that Mr. Pettingill gave of the lady who attends and is vaccinated, goes home, and is found after that to have a positive test. The reality is there is a regime within the order to deal with both unvaccinated and vaccinated people who may turn out to prove positive. So, Lord, if I can ask you to read paragraphs 18 and 19.
So this applies to any person vaccinated.
That's correct. That's correct.
Yes.
And you'll see, my Lord, in section 18.2, a person referred to under subsection 1 who has tested positive or shows symptoms for COVID may be placed under public health supervision, active monitoring, or isolation for a period of 14 days at such person's home or accommodation or at a place approved by the quarantine authority. So these measures are designed at managing risk, they're not designed just to discriminate between vaccinated and unvaccinated people. It's about management of risks with what the health experts called variants of concern. And further to the point Mr. Pettingill made earlier, as we all know, if we have traveled through the Bermuda airport, when you come through the airport and you get a test, you don't actually find out the result there and then. It's not an immediate response testing process. You get the test when you get home.
Yes.
Now, Part 8 Section 22 deals with the circumstance of a person who is unable to quarantine. So there is some discretion that can be exercised with respect to the issue of, for example, cost.
So unable to comply, you think that could apply to financial means?
Well, it's not explicit there. It's not excluded. I don't know what policy decision has been made as to what is included in Section 22, but it certainly is not excluded. I can get some instruction on that. The main point I was making is that there is a provision whereby you can communicate with a health officer with respect to your ability to comply with the quarantine requirements. That may be something to do with your health, because it does health officer. So I have to concede that, but I don't think that it should be overlooked, that there is room for some leeway with respect to complying. One of the concerns that's been raised has been with respect to the report produced by Dr. Pedden regarding some of the complaints people have when they do quarantine. And those are concerns, no doubt, that could be raised under Section 22 to the health officer. So, my Lord, having gone through the most important part of the order, one of the things that we submit is that it would have been easier for the court, and the approach that the applicant should have taken was to consider their submissions in the context of the order. Now, if they're saying that they're not challenging the order, they're just challenging the statement made on the 7th of May, that's a matter for them.
That would make no sense.
But, my Lord, it's not in their pleadings. So I just make that point so that that can be addressed. The declaration that they seek is with respect to exactly what's in paragraph 23. So, my Lord, if I can ask you to again turn to the evidence, the hearing bundle. I'd like you to, my Lord, if you can, look at the originating, again, the originating.
Tab 3.
Yes, tab 3, paragraph 10.
Yes.
Now, my lord, there is a distinction between the assertion with respect to the evidence for standing and with respect to the evidence regarding whether they've been hindered. And I'm going to come to an analysis of the Constitution shortly. But my lord, if you think about it, my lord, we are no further ahead in their evidence than we were when you produced your judgment at paragraph 12. We are no further ahead in the evidence. And so, my lord, at tab 14, so my lord, so in the hearing bundle, my lord, where you were, paragraph 10, what is said is by section 15(1) of the Constitution, the applicants have locus to bring these proceedings on the basis inter alia that the mandatory quarantine contravenes or is likely to contravene their constitutionally enshrined right to freedom of movement pursuant to section 11 of the Constitution. So that is an assertion against the statement made on the 7th of May. And that has to be seen together with your judgment at tab 14 of the hearing bundle. Yeah. Well, if I can ask you to look at paragraph 12, tab 14 of the hearing bundle. It's the grey tab.
I have it.
And my lord, just reminding you of your own words in paragraph 12.
I mean, that was because I was going to hear the application within the next 8 weeks or so. And if they had no plans, I could think of no sensible reason why one would need an injunction. And I decided that they didn't really have the appropriate standing. Do you think that still applies in this case, leaving aside that it's only for 3 months, the regulations? Put that on one side. Let's assume that these regulations were for forever without any limitation as to expiry. Couldn't somebody who didn't have any present plans to travel but was likely to travel have standing?
If the order was unlimited.
Yes.
Yes. My lord, we don't take. I don't want to say we don't take this point. We bring it to your attention. It's a matter for you. It's a matter for you. But we're no further ahead in the evidence. As I said, the order expires in 3 months, and there is no suggestion
that they're going to travel in the next 3 months.
Yeah, and so it becomes more important when we come to the hindered test, because it's a 2-part test on this issue. One, there's a standing point. I'll leave that to you, my lord. And I'll address it later when I turn to the evidence on whether or not there's actually a breach of section 11 in terms of the requirement there's a hindrance. So, my lord, with that said, there is one point I would make before I turn to the law. There is one further point I will make, and that's at paragraph 14 of our submissions. And
yes.
Well, if I can ask you to go back to the judgment that you issued for the interlocutory hearing. and in particular, paragraph 48.
Yes.
And in particular, paragraph 6 of paragraph 48.
Yes.
Lord, you were quite clear in your judgment that there needed to be evidence from both sides with experts who had the relevant expertise. And indeed, my Lord, I think that you expressed at the hearing some concern with respect to the evidence that had been filed on behalf of the applicants. And we take the view that while a number of the doctors are extremely well trained and are obviously highly qualified in their disciplines as doctors for the applicants, they don't have the relevant expertise to contradict the evidence that we have filed in this case.
I mean, part of my concern was that they were all saying the same thing. In fact, they were saying exactly the same thing, i.e. there was a pro forma affidavit which everybody signed up to.
Lord, yes. But I think we go further. If you look at the evidence of Dr. Pedden, and I'll come to that, you look at her qualifications, and you look at the evidence of Dr. Weldon, we say that that evidence of their expertise is directly relevant to the issues that you have and the science that you have to deal with in this hearing. And we say that while the medical doctors the applicant relies on are well qualified in their disciplines, they do not have the expertise that is relevant for the decisions you have to make on
Yes.
the virus, viral load, herd immunity, and all the other issues that we say are relevant when you come to exercise the de Freitas test on whether or not these policy decisions are rationally connected to the legislative aim. So moving on, my Lord, if I can now turn to the law.
Yes.
Now, my Lord, you invited my learned friends, both of them, on several occasions to assist you with the relevant legal test. It is our submission that not only did they not directly answer your inquiry, but the legal test contained in their written argument is wrong. And my learned friend, Mr. Griffiths, leading counsel, suggested that the production of a binder of 23 authorities was designed somehow to obfuscate what the issue was, when in fact it is designed to deal with the fact that they have produced no Bermuda cases, no Bermuda law, no Caribbean law that identifies what the correct test is under the Bermuda Constitution. And my Lord, you hinted for their benefit as to where you would find the correct test when you referred to Saunders. Now, as you may know, my Lord, Adrian Saunders is the president of the Caribbean Court of Appeal. And that book contains numerous references to Caribbean constitutional law and the application of the relevant test in this case. So, my lord, what has happened in this case is that there has been a failure to refer to the relevant Bermuda authorities, and it has led to a total misunderstanding of how this argument should have been made. In synopsis, my lord, and my lord will be aware of this from both the Bermuda Constitution and other Caribbean constitutional models, influenced in part by the European Convention and the Canadian Charter of Rights. With the Bill of Rights provisions in these constitutions, there is an assertion of a right that is protected. The applicant has the burden of establishing that that right has been infringed. The burden then shifts to the state
Yes.
to explain whether that infringement was reasonably required.
Yes.
If the state satisfies that burden, the burden then shifts back to the applicant to demonstrate that the measures that were used were not reasonably justified in a democratic society.
Yes.
Now, as my lord will know, and I'll take you to the cases, we have two Bermuda cases of note, Benavides and Rayner and Richardson, from two senior predecessors on the court, Mr. Justice Kawley, Chief Justice Kawley, and Mr. Justice Hellman, that set this test out, and I'll take the court to that. Well, Lord, the important thing to understand, and you would have gleaned this from Saunders, and I'll take you to this, is that in some Caribbean jurisdictions, you only have a reasonably requirement upon the state. You don't have an obligation for the burden to shift back to the applicant. Now, in those jurisdictions, the proportionate test, or a form of it, that my learned friends seek to rely on, becomes a part of the third limb of the de Freitas test. But in jurisdictions like Bermuda, where you have a reasonably justifiable in a democratic society saving clause, the proportionate test is more aptly relied upon in the element that places the burden on the applicant. And you get that from Saunders. Now, what the courts have said, and what Saunders says, is that over time, the de Freitas test, which my lord will recall, is the binding test on Bermuda because it's a Privy Council case, not the cases my friends have referred to. What they have said is the de Freitas test needs to be strengthened in the third limb, and so there is an element of proportionality that comes in there. But my lord, the way this would work in practice is that the applicant satisfies the burden that there's been an infringement. The state then has to reply and demonstrate that the particular provision was reasonably required. It does that by satisfying the three-part de Freitas test. Now, during the course of the evidence, of course, the applicant will respond to that three-part de Freitas test. And then if the state satisfies that three-part de Freitas test, the burden will shift back to the applicant on the reasonably justified test. And when it shifts back to the applicant, they will then use a form of proportionality, which I'll take you to, in order to satisfy that element of the test. The problem, and I'll take you to this in the Scottish Philip Scotland case. The problem that's identified in paragraph 100 of that case is that the proportionality test is a test that's used, first of all, it's not used in Bermuda. And secondly, it's used more to challenge legislation in European countries. And so we have to be very careful about applying the test. Now, let me be candid. When we come to Bank Mellet, in paragraph 20, when they devise the proportionality test, 3 limbs of that proportionality test are the de Freitas test. The 4th limb is the added limb that, based on my learned friend's argument, they're saying applies to the respondent, and it does not, because we have the de Freitas test. And my lord, I'm going to take you through this, but I'm just giving you a synopsis now of why I say the applicants have got the wrong test. They're imposing a 4th limb Bank Mellet proportionality obligation on us that does not exist because of the de Freitas test. So, my lord, let me now take you through that so you have the correct test and you can see why the test that has been adopted thus far is wrong. Lord, if I can start with paragraph 17 of the skeleton argument, and that takes us to the case of Benavides, which is at tab 11 of the authorities bundle.
Yes.
My lord, if I can ask you to read, I'm sure you've seen these paragraphs before, and I apologize for asking you to read 2 pages of this, but everything is relevant on these 2 pages. Paragraph 34 to 41 sets out the test quite clearly. Now, Benavides, as my learned friend, Mr. Griffiths has already said, is a case with respect to the rights of union members to be unionized when they were white-collar workers. But the law is pertinent and relevant to the burden, the shifting of the burden, and the appropriate test from the Privy Council. Which said, what's it? Paragraph 12. So distinction based on right.
Yes, I've read it.
And my lord, one of the points that was made earlier was that there was a distinction because it's a different provision of the Constitution. Lord, can I ask you to look at paragraph 12 of the same case? You'll see that that's a reference to section 10 of the Constitution. I could have taken you to tab 1, but you will see that section 10.1 creates the protection.
Yes.
Section 10.2
reasonably required
is the justification for the state. And then section 10.2b has the reasonably justifiable in a democratic society. It's the same template, it's the same format. Lord, could I also ask you to look at...
Let me just look at section 11 of the Bermuda Constitution, which is a tab 1. Just 1 second.
Lord, yes, I should have taken you to that.
Yes, I see that it's the same format.
Sorry, Lord, it's the same format, yes.
Yeah.
Lord, it is a, Lord, I've also I mean, if you look at, we are going to come on to section 12. Section 12 of the Constitution becomes very important for the purpose of this argument, for this reason. My Lord, section 12 is the discrimination section. There is a case that was decided by your sister judge, Mrs. Justice Sade Subir. And you can see that section 12.1 creates the protection. Section 12.3 sets out the definition of discrimination. Section 4 creates the savings, and the important one is section 4D.
Yes.
And we will see that there is one case, it's the case of Ackroyd, in which the Bank-Mellett test was applied to reasonably justifiable in a democratic society by your sister judge. And I'll come to that. But before I come to that, my Lord, if I can ask you to look at tab 27. It's the case of Richardson and Rayner.
Yes, I have it.
Lord, if I can ask you to read paragraphs 12 and 13. Set. Yeah.
Yes, thank you.
And if you can look at paragraph 7, my Lord, you will see that the schematic is exactly the same. It is a schematic based on the European Convention of Human Rights. As I said earlier, the protection is created, the restriction on the protection has to be reasonably required, and then the burden shifts to the applicant to show that it's reasonably justifiable in a democratic society. So, my Lord, what we have, and I'll continue, but giving you a headline of where we're going, is what we have is the applicants relying on the case of Bank-Mellett, which is a proportionality test in a public law context, not in a constitutional law context. And they're applying it as the test that the state have to satisfy when we come to the reasonably required obligation. When in fact, the Bank-Mellett test of proportionality has only ever been applied by these courts when the burden is on them dealing with reasonably justifiable, at which point the burden shifts. So they clearly have the wrong test. Lord, if I can ask you to
Yes.
I can ask you to look at tab 23. Tab 23 is the judgment of your sister judge, Justice Sade Subir Williams. And
I think you got the wrong tab, or I had the wrong tab.
not the Ackroyd.
Is Rotherham. Which one are you looking at? Ackroyd is 25.
25, okay. My apologies. Lord, this is a case about belonger status in sections 11 and 12 of the Bermuda Constitution Order. For our purposes and seeking to identify where, if at all, bank melit is relevant in this jurisdiction, we can look at section 12 of the Constitution, in particular at paragraph 13 of the judgment. So the learned judge sets out the reasonably justifiable test. Now, my lord, at paragraph 32, there is a reference to the Timberland case, which I'll come to as well, and also to bank melit. And my lord, at paragraph 67, the learned judge begins to analyze the reasonably justifiable obligation on the applicant and so you can see, my lord, that to the, and then, my lord, ringing again some of the comments you made earlier, you see what your sister judge says at paragraph 72, which is an endorsement of the Dolan point that you've made and other comments you've made with respect to polycentric questions and political choices.
Yes.
So, my lord, where we are in Bermuda is that bank melit, at best, can be used by the applicant when the burden shifts back to them, if it does. I mean, obviously, the state has to satisfy its obligation under reasonably required, but bank melit is not the test for the state. The test is de freitas, and let me take you to that.
Yes.
It's been referred to in the it's at tab 14 of the authorities bundle. And the Lord may recall, this is a case about a civil servant who was participating in demonstrations and was prohibited from any communications relevant to those demonstrations. He mounted a constitutional challenge with respect to the Antigua and Barbuda Constitution. But for our purposes, the main part of the judgment that has become seminal for interpretation of the reasonably required obligation in Caribbean constitutions is on page 684 at paragraphs C through to F.
The report I have is page numbers are not clear.
684. It's the penultimate page of the judgment.
Yes. Yes.
But it's the same. Is that right? Oh, I see. That was one from the interrogatory.
Yes.
Now, Lord, we say, which must be a matter of practical application of the Brady's test, that the evidence does not fit into three separate compartments regarding the three separate criteria. So the evidence with respect to the legislative objective will probably be part and parcel of what is considered when we look at the measures that are designed to meet that objective rationally, and whether or not the means used to impair the freedom or right is no more than necessary. There'll probably be some overlap, and we refer to that in paragraph 18 of our skeleton argument. And in particular, a case called Timberland Limited versus Minister of the Cook Islands, which hopefully you'll have at tab 22 of the binder.
I do.
Well, the Timberland case was, the facts aren't material. It concerned a superannuation scheme set up by the Cook Islands, which was challenged as being unconstitutional. The relevant paragraph that we rely upon in that judgment is paragraph 36. And if you see the last sentence in paragraph 36, it is the quote from Lord Sumption, but it explains the proposition that we rely upon. So,
Yes.
Lord, in our skeleton argument, paragraph 17, footnote 10, there are a number of other cases we refer to that arose following the De Freitas case. If I can ask you to look at Observer Publications and Matthews, tab 12.
Yes.
And if I can ask you, my lord, to read paragraph 25. I was going to say.
Yes.
And the case of George Worm and the Commissioner of Police of Grenada, which is at tab 13. And Lord, if I can ask you to look at paragraph 41.
Yes.
So, my Lord, these are Privy Council cases. These Privy Council cases set out the test to be applied by this court. Those judgments, I say with respect, my Lord, are binding on this court, as opposed to the authorities that have been referred to by the applicants. They set out a different test. They demonstrably show that the test that the applicants have applied is wrong. And the only instance in which the Bank Mellet case has been referred to in Bermuda is with respect to a test that is upon them if and once the burden shifts to them, if the state has established on the de Freitas test that the measures that they have implemented were reasonably required.
Yes.
Look, the last reference that I want to take you to is Saunders, because I want, my Lord, you to have a clear understanding of the proportionality issue. I think I've already dealt with the suggestion.
I read parts of it, but show me the bits you want me to look at.
So, well, you can see on page 439 that at paragraph 9021.
Does Mr. Pettingill have that? And
Yes, it was sent to him. Yes.
yes.
I do, my lord.
You can see, my Lord, on page 439 at paragraph 9021.
Yes.
The author synthesize the propositions that you have just gone through in the Privy Council cases and the Bermuda case of Richardson and Rayner and the Bermuda case of Benavides. So there's a synthesization of that. And you can see over the page at 9022, there's a reference to the burden of proof. And part of that is what was referred to by Mr. Justice Hellman in the Benavides case, where he clearly states that the old heresy of thinking that the burden didn't shift to the state is gone. Now, my Lord, we then turn to 9023, rational connection and proportionality. And my Lord, you can see, if I can just give you some headings to try and just categorize the constitutional thinking on this. If I can take you to paragraph 9024, you see the heading Roman numeral 3 is the single test reasonably required, or reasonably justified. That is the test when only one of those statements is made in the constitutional provision that is being used for challenge. If you turn over the page, you see the heading, the two-tier test in conventional bills of rights, reasonably required and reasonably justified. That's what we have here in Bermuda. You have a reasonably required imposition on the state, and then the burden shift, and there's a reasonably justifiable requirement that goes back to the applicant.
Yes.
My Lord, I'll take you through the actual extract, but my Lord, just so that I can explain, the thinking is this. If you have the applicant satisfying the burden that there has been some hindrance or some challenge, and the burden shifts to the state, you've got that three-part test. The thinking is that if you have a three-part test that applies to a constitution that only has one reference to reasonably required or reasonably justified, then the third limb of the de Freitas test has a greater element of proportionality. And you will see, and you may recall, they call it the Huang gloss. And I can take you to the case of Huang. But if you have a two-part test, as we have, then the proportionality element is in the third part, but not to the same extent. And the reason for that is because if you think about it, what the court is doing is it's assessing the provision as a whole. There's a challenge alleging infringement. The state tries to satisfy the rationality test based in de Freitas. There's an element of proportionality, but then when the burden shifts back to the applicant, they have to satisfy an element of proportionality by showing that what they seek demonstrates that it would not be reasonably justifiable on a proportionate basis for the state to be able to carry out the particular activity. So the proportionality test, there's no point, my Lord, in having a proportionality test imposed upon the state on the third limb of de Freitas, and again on the applicant when they have reasonably justifiable. You're dealing with it twice.
Yes.
And so that's why if we have the single test of reasonably required or reasonably justified, that burden rests with the state under the third limb of de Freitas. So that's why the application of Bank Mellet cannot be used in this case. It doesn't properly assume where the proportionality test applies because it doesn't take into account the fact that we have reasonably required and reasonably justified. So that's the synopsis of that. And my Lord, briefly just going through this, if you look at rational connection and proportionality, if I can ask you to look at page 443, and if I can ask you to actually read that page, you will see what I have said is set out by the authors.
Yes, I mean, I've highlighted it, but I'll read it again.
Why was it? Actually, in my name. Yeah. Yes. Lord, before you turn over, you'll see at footnote 220, there's a reference to Huang, which is called the Huang gloss. You'll see that. Now, my Lord, if I can ask you to turn to, keep that page because I'm going to come back to that and then go over the page. But if I can ask you to turn to the applicant's authorities.
Yes.
And Bank Mellet. Can I ask you to look at Bank Mellet, please? And that's in the House of Lords, not in the Court of Appeal.
Yes.
And my lord, we've all been through Bank Mellet. So if I can ask you to turn to paragraph 73, there is a reference to the case of Huang and what the Huang gloss is. So rather than provide the whole case, I've just got the extract of Huang from the Bank Mellet case, paragraph 73.
Yes. Yes.
So my lord, that is the gloss. That is the Huang gloss that referred to. And when I take you over the page, my lord, if I can ask you to look over the page. My lord, just bearing this in mind, it may be that at the top of the page, the reference there to how you assess proportionality may be a guide for how the court assesses. There's a three-part test. So you see, they say as part of the analysis of strict proportionality, the overall sacrifice imposed on a restricted right with the benefits derived from pursuing the aim must be rigorously weighed. And then they give you a guide as to how to do it. First of all, and we'll come to this when I go through the Freitas test, but first of all, one has to look at the level of the harm to the rights.
Where are you? What page?
444. So I had you read 443, and then over the page finishes that particular section talking about proportionality. This is in, I'm sorry, this is in Saunders.
Yes, I haven't.
Right. So you'll see the last sentence, if you read the last sentence of 443 and then the first paragraph on 444.
Yes.
So what we have is a floating test of proportionality that, depending on the wording of the constitutional provision that we're dealing with, applies to a lesser degree in the third element of the Freitas, or to a greater degree upon the applicants when they have a burden if it shifts to them. And Lord, you will see the fourth element that was added to the De Freitas test in 443. You've already seen that. And now, my lord, if we come and look at paragraph 9024, you will see the analysis of the court where they talk about the Huang gloss that applies if you've only got a single test. And it makes sense. Because if there's no burden shifting back to the applicant, then under the third limb of De Freitas, there would be a greater obligation to satisfy the proportionality test based on the stricter requirement that you see at the top of the page, because there is no burden shifting to the applicant. But if, as we have in our constitutional provision, the burden does shift to the applicant, then the state is required to satisfy the de Freitas test. There is a proportionality element in there, you've seen that, but there's also a strict proportionality element upon the party seeking to say that the state does not have the right to invoke the provision. And my lord, if I can ask you again just briefly to look at paragraph 9025 of Saunders. I think it's going to be helpful when we work out how to deal with the shifting burdens in this case. It's 3:58. What time is it now? 4 o'clock. We're going to stop. We're on a roll. Let's just keep going. We're on a roll.
I think you should, if you're still doing with this, then I will continue. If you're going to
Yeah. So, my lord, do you see that on page 446? I apologize, it is a long read, but it is all, I think, relevant to the analysis you're going to have to carry out. On paragraph 446, is reasonably justifiable in a democratic society. The default element, on the other hand, should be understood to impose an added and overriding standard that goes beyond the three-part test and to imply what we have referred to as the Huang gloss. The default element establishes an irreducible minimum standard below which that society must not go. The overriding test of reasonably justifiable in a democratic society would survey the broader implications for that society of limiting the protected rights. It would give more consideration to balancing the protected rights against the interests of society, asking, is the infringement too high a price to pay for the benefit of the law? It would scrutinize more closely the severity and consequences of the interference on the right. The demands that the most serious consideration be given to the values that have reformed the right when balancing against the public interest. Reasonably justifiable in a democratic society as an overriding standard is not an entirely abstract, transcendent notion. It also permits consideration of local considerations. Simply put, the overriding test of reasonably justifiable in a democratic society requires further scrutiny to achieve an appropriate balance between the interests of the society and those of the individuals and the groups affected, the element that is missing in the three-part de Freitas test. And you'll recall, my lord, from the previous page 445, that there is confirmation that the reasonably justifiable element shifts back to the applicant. Now, my lord, there's a reference in our authorities to a case of Robinson and Seeley, which we couldn't find, and you'll see that there's a reference to it in paragraph 9025. So we don't need it for any more than that. So, my lord, I think that that is all I wanted to say about the test before I move on to margin of appreciation. And I don't know whether now is an appropriate time to have a break or not. I think we went past your... We can't hear you. We can't hear you.
You're on
We'll
mute.
take a break now.
Oh, we can hear you now.
Yeah, sorry. We'll take a 10-minute break now. And depending on how you feel, if you wanted to go longer than 4:45, we could do till 5.
Okay, my lord. I'll see depending on where I get to.
Yes, that's fine. So let's take a 10-minute break.
Courtney,
Yeah?
nothing happened today because there was jury selection that just took up both courts. So I've prepared the officers.
Hi, Courtney.
We need to liaise.
Courtney, can you go on mute? Just mute your microphone.
I'm just going into court for the afternoon sitting on another matter.
Yes, Mr. Duncan.
Lord, Lord, I don't think as a a matter just of pro forma, that I've actually taken you through section 11 of the Constitution at tab 1 of our authorities bundle. It will only take me a minute just to make sure that I
I
highlight.
looked at it whilst we were looking at other sections,
Yes,
and it's in that context I said that it follows the same format.
yeah. Paragraph section 11, it's page 18.
Yes, it's subsection 2.
Yeah, but before we get there, my lord, at section 11.1, I'd like you to note the word, no person shall be hindered in the enjoyment of their freedom of movement. And then you'll see at section 2A that there is a reference.
And the expression hindered is the same as in section 8.
Yes, that's correct. And you'll see at section 2A that the restrictions, if any that are going to be placed, must be reasonably required. And, my lord, you'll see that for our purposes, we're dealing with section 2A1, the references to public health.
Yes. And you say the burden of proof in relation to that is on you.
Burden of proof in relation to reasonably required is on the state, and within the Caribbean constitutional model, it's based on the De Freitas test.
Yes.
And when we get to, now, my lord, conceivably, if we don't satisfy the test, and that's what was referred to in Saunders, you don't get to reasonably justifiable in a democratic society if we don't satisfy the burden that is upon us. But if we do satisfy that burden, then that burden shifts to the applicant, as you can see in section 11, to demonstrate that the measure is not reasonably justifiable in a democratic society, and you now have the assistance of the cases which I'm going to contextualize and take you through as I go through the evidence and
Yes.
the De Freitas test.
So your submission is, as far as the burden of proof is concerned, for section 11.1, hindered in the enjoyment, that's on the applicant.
That's correct.
2A, reasonably required, is on the state using the De Freitas test.
Yes.
And under 11.2.2, except so far as the provision, etc., that is once again on the applicant.
That's correct. That's on the
Yes.
applicant again. Yes. And we say that references to balancing of interests are all inapposite. The language that was used by my learned friend, both orally and in his written submissions, is just not appropriate for the exercise that you have to perform. The exercise that you have to perform is strictly constrained by the Privy Council determination in the De Freitas test. So, my lord, with that, if I can now move on to paragraph 19 of
Yes.
the skeleton argument.
Yes.
Now, my lord, I say with respect, on various occasions, you have either hinted or expressly referred to the margin of appreciation in different terms regarding the polycentric questions that you understand this government is faced with these measures that it has taken. There is no reference in the skeleton argument of the applicants, no reference in their authorities to the seminal and important legal authorities that you have to consider regarding the margin of appreciation when it comes to these, as I keep saying, polycentric decisions that the court is required to make. So, my lord, in paragraph 19, we consider the authorities, we say that the applicant is also bound by in this case. The first is Dolan, paragraph 7. My Lord, I'm not going to take you to that because I think you've read that so many times, but there's the extract that is relevant. Court is not responsible for making political, social, or economic choices. The court is not responsible for determining how best to respond to the risks to public health posed by the emergence of a novel coronavirus. Those decisions and those choices are ones that Parliament has entrusted to ministers and other public bodies.
I mean, those principles I referred to in the previous judgment, and on the face of it, they make sense. How does it apply in our context when we are applying the test which we just looked at? Say, for example, we are at stage 2A, where the burden of proof is on the state to justify that the restrictions we're concerned about, the regulations, are any class of persons that are reasonably required on the grounds of public health. In that context, how do these principles apply? How do you synthesize what is said in cases like Dolan,
Well,
and in seeking to discharge the burden of proof under 11.2a?
Lord, the cases assist with this. So if you look at the de Freitas, we've got 3 tests in de Freitas. First of all, you've got to establish that the state is charged.
Yes.
And you have this already, so I don't want to exercise your hand on this. You have this.
Yes.
The state has to establish that the legislative objective is sufficiently important to justify limiting a fundamental right. There would be an element of a polycentric consideration there, because the state would have to explain why it is that the particular measure it's seeking to impose is not only the appropriate measure, but why it is important that they be given the range of responses that they should be able to make to actually make that decision. You'd have that at stage 1. You'd also have that at stage 2, whether or not the measures are designed to meet the legislative objective and they are rationally connected to it. When it comes to determining whether or not there has been a rational determination by the state, the court has to give the state a degree of margin, so that if the court says, look, I don't think that that's particularly a rational response, the state is entitled to say, this is the range of responses that we had available to us. In this case, we're talking about funds, we're talking about the evidence of risk, we're talking about the fact that on prior occasions before this policy was implemented, we had these cases that caused the government to change their mind. With those kind of factors in place, when you, as the court, have to determine whether or not the response is rational, you have to say, look, I have to give them some latitude, because if I were to analyze this in a public law irrationality context, which is what the judicial review cases do, and that may be the distinction between the judicial review regime and the constitutional regime in this context, the state can't do that. The state cannot be responding in the way that it would respond to a judicial review, say, rational challenge, because it should have a margin to determine whether or not it should or should not make a decision, particularly in this case where you have a declaration of a state of emergency. So, my Lord, I don't know if that helps, but essentially you apply the de Freitas test, but you then have to say, we have to give the state a degree of width and a margin to make decisions that may be decisions that we cannot necessarily say are directly the decision that a court would make on a judicial review application, but they are decisions that it's reasonable for a state to make.
In this Scottish minister's case, the judge was seeking to apply the Bank-Malat test, and nevertheless, he did apply he did give deference to the decision maker, given that the complexity of the decisions which had to be made and the conflicting evidence. I was just trying to see how one actually synthesizes this aspect of the review with the de Freitas test, and I suppose the answer is that both apply.
Yeah, both apply, but I think, you know, to some extent you have to get into the weeds of it. And by that, what I mean is that as you go through each limb of the test, you then have to ask yourself, is that response a reasonable response to the test? And if you say that is a reasonable response, then you don't need to go to the margin of appreciation as much. But if you say to yourself, that response gives me some concern, you then have to then default to the margin of appreciation and see whether or not that response is within the margin you're prepared to give a state on a polycentric question.
Yes.
I think that's probably
Yes.
limb by limb of de Freitas. It probably requires the application of that test.
Yes.
I mean, thinking about it a little bit further, my lord. And I'm not sure whether you're looking. I certainly haven't found a principle. I mean, I suppose there are two approaches. You could either do it in the sliced and diced way that I've just mentioned, or you could look at all three limbs of the de Freitas test, consider the government's responses in the round, and then determine whether or not the margin of appreciation should be applied. I haven't thought through, I haven't found authority on that. I haven't thought through which is the best approach. I would have thought that the analytical approach would probably be better, but it may be on reflection, and I'll come back to that, having thought about it overnight, that because of the nature of the evidence that you are considering, and because of the fact that based upon Lord Sumption's assessment of the de Freitas test, he says that the evidence on one point may apply to another. It may, on reflection, make more sense to apply the margin of appreciation at the end. But I'll think about that and respond to that fully tomorrow. So, my lord, I'm on paragraph 19b of the skeleton argument. And that talks about, I mean, my lord, I think it refers to something that you have said in response to my learned friends, which is that the ministerial and government response is not a counsel of perfection. Of course, they have to be subject to scrutiny. Nobody is saying that these decisions are beyond the law. That's why we're here now. But within the range of responses that have to be made in the midst of a pandemic, with a fast-moving situation, with different variants being reported as coming into the island at different times, I think there is, quote unquote, a margin of not error, but appreciation you give to the government so that they can make and take a range of responses that shouldn't necessarily be subject to challenge, particularly when it concerns, on the evidence that we have, a latitude that, and this isn't seeking to cast blame, we don't know the precise causal way in which the 21 deaths arose, other than from what the minister says, which we accept. But on the back of that, one would have to think that a ministerial response and the court's assessment of the appreciation that it would give the minister would be slightly wider, because we don't want another situation like that. And so the range of responses that a minister is going to take with that at the back of her mind has to be something the court would consider and giving a wider latitude. My Lord, and there is reference to that degree of latitude that should be given to ministerial response in the case of Eastside Cheese Company. That's a reference to a judgment of Lord Bingham at, so I think it's a tab.
I have marked that passage. I read it yesterday.
Oh, if you've read that already, then we can leave that, Lord.
I mean, paragraph 90, standing alone obviously makes eminently good sense in the Court of Appeal in Dolan, which you have cited
Yes.
in your written submissions. How does one apply that here?
Apply, sorry, what? The Dolan?
Paragraph 90 of the judgment in Dolan. I mean, standing alone, one reads that and says, yes, that all makes very good sense. How does one apply it to the facts of our case?
Well, first of all, this was a JR considered a question of irrationality. And we have to be careful, because we're considering
Constitutional
the
provisions.
opposite, which is a rational connection as opposed to irrationality. And I am a little bit concerned about going down the judicial review road. But on the general principle of margin of appreciation and irrationality, I mean, obviously, if you're applying the de Freitas test and you are at limb 2 and you form the view that there is no rational connection between the legislation and the aim and the measures that are taken, so you have that on one side. When you come to consider the margin of appreciation, it may be that we fall on the outer bounds of that. And so because of the fact that we either struggle or cannot, and I don't say that's the case here, because I say we do satisfy the rational connection test. But let's say, for argument's sake, we struggle. And, there was a struggle with the connection, and you took the view that it was tangential, and you wanted debate on that. We then come to the margin of appreciation, and that's where, based on the debate we had earlier, you could consider whether you would consider margin of appreciation at limb 2, or you would wait to determine whether or not limb 2 made it impossible for the state to satisfy limb 3, and then margin of appreciation, together with any other argument, could be determinative in your mind and say, well, look, perhaps the respondent has failed to satisfy the test. But I mean, analyzing it, the predominant analysis that you would have, I would submit in your judgment, would be a failure to satisfy the rational connection test. And then I'll add it on top of that. You could probably say, and I'm not prepared to give the government the margin of appreciation in making the decision because they haven't satisfied the test. I'm not sure if that's helpful.
Yes.
Now, just sticking with paragraph 90 for a moment. I mean, it's interesting. If you read paragraph 90 with the two sentences disjunctively separate, you will. I mean, the second sentence is eminent sense, but the first sentence obviously was of concern to you, my lord, because if it was established that the measure was irrational how do you get to the second limb? So it seems as if this may have been a stark example that the court was using. Although, my lord, if we turn over the page of our submissions, we see the conclusion of the thought of, I think it was Lord Burnett, with respect to the question that's posed in paragraph 90. In paragraph 97, do you have that?
Yes, I do.
Our skeleton argument.
I mean, the margin of appreciation was utilized by the European Court of Human Rights in the case we looked at last time. On the basis
Czech
that,
Republic case. The Czech
yes,
Republic.
Czech Republic case. In the
Yeah,
Czech Republic case, they said in considering whether the measure is in accordance with the constitutional provisions, they do take into account that issues such as public health are such that the court would give the national governments a wide margin of appreciation.
Yes, yes. My lord,
And that's your next case, E. That's the Czech Republic case. They specifically referred to that.
yes, they do. And that's
And in fact, in that case, there's quite an extensive review of the national legislation of member states where similar principles are articulated.
yes. So, my lord, I mean, I will contend that once I go through the detailed assessment of the evidence as it applies to the De Freitas test, the margin of appreciation will only add to the fact that these particular measures were reasonably required. My submission is you're not going to be left in a situation where...
No, I understand that. I'm interested conceptually how this aspect of it applies to a constitutional challenge. That's the only reason
Yes.
I'm
Yeah, and I think, my lord, I mean, and I'm thinking as the questions are posed, it must make sense, not that my original submission is correct, which is that you slice and dice De Freitas and apply the margin of appreciation to each limb. It probably doesn't make sense. It doesn't make sense because of the rider that Lord Sumption put on the test, where he said that the evidence can overlap for each limb. It's probably more of a common sense approach for the court to say, look, I've heard all of the evidence on all three limbs, and added to that, I will apply the margin of appreciation. I'll either give the benefit or not give the benefit to the state. I think that's probably the way to approach it. And I think that references to irrationality in the UK judicial review context may be a little bit dangerous, because if anything, it's the opposite of the test you have to apply in De Freitas.
Yes.
So, Lord, if I can ask you to look at, you've already considered and read our Czech Republic reference. And so if I can ask you to turn to paragraph F. That is a case which, for shorthand, we call Rotherham. It's at tab
23.
Ah, right. 3.
My lord,
Yes.
I wonder if I could interrupt for a moment to mention
Yes.
that it's gone 2:30 here in the Cayman Islands, and I've just received contact to pop into the court where I'm doing a criminal trial at the moment.
Oh, right. I think in that case, I'm quite happy to rise at this stage. Will you be available tomorrow?
I'll be available early tomorrow morning, because
Yes.
when you commence at 9:30, it's 7:30 in the morning here.
Yes.
So I should be able to respond to what my learned friend, Mr. Duncan, has said. And
Well,
that should take about an hour or so.
how long will it? I mean, Mr. Duncan has, I think, quite a way to go yet. He hasn't dealt with the facts. So I think.
But Lord, I'm sorry to disappoint my learned friend, but I wouldn't like to say we've only just begun, but the reality is that I have to set out to the satisfaction of the court the rational connection test as applied to the evidence, and I haven't started that yet.
So I don't know how we're going to do this, but I mean, my suspicion is that Mr. Duncan's got another 2 or 3 hours to go yet.
That's about right, my lord. Yes, that's about right.
So, I mean, if it helps, we could start at 9, but that still won't help you.
Well, my lord, I'll discuss the possibilities with my learned friends
Yes.
who I'm working with, who
Yes,
could perhaps take a note of what is being said by my learned friend, Mr. Duncan.
Yes. Well, I think we work on the basis that, I mean, I want to finish it tomorrow, Mr. Griffiths. So I think after Mr. Duncan finishes, either you or Mr. Pettingill will have to respond.
I totally agree.
Yes.
And so we can have a discussion about that, hopefully later today.
Yes, I think you should have a chat with Mr. Pettingill, and I suppose in theory, both of you should be ready if one of you can't make it. So I think, Mr. Duncan, if in the present circumstances, given Mr. Griffiths has to go to another court, I'm quite happy to adjourn at this stage.
I'm quite happy to.
Would it assist you, Mr. Griffiths, if we started at 9 or 9:15, or is that even worse for you? Because that's like
No. I'm willing to wake up early.
All right. Well, in that case, let's adjourn now, and we will start at 9:15.
I'm grateful.
Recapture some of the time.
Thank you.
Yes, very well. So for the time being, this hearing is concluded, and we will adjourn till tomorrow morning at 9:15.